The civil society organizations represented by the Center for Health, Human Rights and Development (CEHAD), Food Rights Alliance Uganda, FRA, Siatini Uganda, and Action Aid Uganda filed a case against the government requesting the Constitutional Court to declare the Plant Variety Protection Act of 2014 null and void. The petitioners urge that the Plant Variety Protection Act is unconstitutional because it gives all the produce cultivated by farmers to the owners of the seeds, plants and propagating materials which farmers have used to cultivate the produce.
When you look at the law, it is basically for commercial breeders and it is benefiting commercial breeders at the expense of smallholder farmers. But as we all know, smallholder farmers in our food system have been breeders of seed and other propagating materials over time, but here is a law that left them out.
The petitioners accused the Speaker of Parliament, Rebecca Kadaga, for not having quorum in Parliament before passing the Plant Variety Protection Bill 2014 on December 20th, 2013. The civil society organizations say this move denied parliamentary representatives of many farmers the right to choose whether they wanted the bill to become a law or not. Moses Mulumba, the executive director of Center for Human Rights and Development, says consulting the rights of the citizens when they were creating the unlawful provisions of the act automatically took away the rights of farmers.
But when you pass a law without quorum, it actually means that the communities that sent these members of parliament to come and represent them are actually negated in the process of passing the law. So that becomes problematic. The last issue that's a problem with this law is the requirement of this law that even on first sale, the rights of the plant breeder will continue to chase the person that has bought a breed, to encourage them not to sell or any other commercial purposes of a breed that will be a result of their innovation.
The Parliament of Uganda has on several occasions, including while creating the Marriage and Divorce Bill 2009 and the Biotechnology and Biodiversity Bill of 2010, instructed its members to consult their constituencies on matters being legislated to ensure individual participation in the legislation. However, this was not portrayed on the Plant Variety Protection Act of 2014.
Because the law was passed without the ascertainment of quorum as required by the Constitution and other applicable laws. The second issue is the absence of adequate consultation in the making of the legislation. Any legislation that's affecting society, there should be adequate consultation of society. We are not clear with Parliament's way of doing business because in passing some legislation, Parliament goes back to the communities and does the consultation, like the Domestic Relations Bill. When it comes to a very critical law like this that's affecting agriculture, which affects 80% of the population, nothing like that actually happens. So we think this violates Article 38.
To avoid being dragged to the courts of law, CEHAD, FRA, Siatini, and Action Aid Uganda hereby call upon to the government to act urgently and correct these irregularities. Kawesa Lubama, WBS TV, CEHAD Uganda.